welcome. Last time, a series of challenging questions was presented to WA's Attorney General to either affirm or deny various statements as facts in law. Why was it necessary to even ask such questions? How did we arrive at such a state? Whenever we find ourselves in an undesirable situation, it's advisable to backtrack to find out where we might have gone astray. This is done much more easily in, say, a Sudoku puzzle than in unravelling the twists and turns of history, but the exercise must be done if we are to uncover enough truth to remedy things. In earlier videos, reference has been made to numerous acts of treason aimed at undermining the British Constitution over many centuries. This time, we're going to study one of the most sinister and influential of these, the Bill of Rights of 1688-89. First, we need some background information. The 17th century in England was one of the most tumultuous of all. The strife over which of the two major strains of Christianity was going to prevail was unresolved. Succeeding monarchs belonged to either Roman Catholicism or Protestantism, with successive waves of persecution washing back and forth over the land. This culminated in a series of civil wars, generally classified into three main divisions between 1642 and 1651. These were eventually won by the parliamentarians led by Oliver Cromwell, who defeated the royalists under Charles I. The latter was executed for treason, partly because of his plan to bring foreign troops onto English soil. Irish soldiers did fight in these wars, but this was a public relations disaster for Charles, who many people suspected of organising an Irish invasion. Other reasons were Charles's absolute insistence on the divine right of kings to rule as they individually saw fit, and his persistent refusal to accept parliamentary proposals for resolution of these divisive issues, which included economic as well as religious disagreements. Following Parliament's victory, there was a period until 1660 known as the Interregnum, where there was no monarch. Cromwell established a Commonwealth or Republican form of government, but this was an arbitrary decision of his because the victors couldn't decide on what form a new constitution should take. Cromwell died in 1658 and his system wasn't very popular. Accordingly, it was comparatively easy for the people to be convinced to restore a monarchy, and Charles's successor, Charles II, was installed in 1660. Relations between him and Parliament weren't smooth, and he was succeeded by his brother, James II, on his death in 1685. James II was the last Catholic monarch of England, but was not popular because of this still simmering conflict between Roman Catholicism and Protestantism, and the philosophical dispute over the divine right of kings, etc. Eventually, it was decided among some nobles, dubbed the Immortal Seven, to invite William of Orange to England and establish once and for all a Protestant supremacy in the monarchy. Accordingly, William of Orange, James's son-in-law, landed at Brixham on November the 5th, 1688, with an invasion force. James was so disheartened by his abandonment by his military officers and defection by his own daughters to William's side that he attempted twice to flee the country, eventually making it to France just before William and his army entered London on December the 8th. William was installed as joint monarch with his wife Mary. However, his ascension wasn't fully secured until some violent conflicts, notably the Battle of the Boyne in 1690, where James was defeated in a battle still celebrated every July the 12th in Northern Ireland, and the Battle of Aughrim, and the massacre of Glencoe, 1692, where 38 members of the MacDonald clan were slaughtered by their guests, the Campbells, for refusing to pledge allegiance to the new monarch. So it was not as peaceful a transition as is often claimed, and some historians maintain that the so-called Glorious Revolution was really a cleverly executed foreign invasion and coup of England by the Dutch. The English and Dutch had fought a series of 3 wars over trade between 1652 and 1674, about fishing rights in the North Sea and control over the Dutch colonies in what is now the New York area. Though these 3 wars were mainly in favour of the English, who renamed New Amsterdam as New York in 1664, William would doubtless have considered it a most satisfactory outcome to be personally crowned as monarch of the country which was so distressing his own. History, as they say, is written by the victors. With triumph in the encounter comes the naming rights. Having set the scene, let's turn to the deceptively named Bill of Rights. While it is true that Dutch settlers in the New Netherlands in North America had enjoyed greater personal freedom and liberties than those in the English colonies, there were factors at work in England to ensure that no such advantages should accrue to English citizens at home. There existed in England a wealthy, self-interested oligarchical clique who styled themselves the Estates of England. This was supposedly a 2-tiered system, but was only one. It was comprised on one hand of the high-ranking prelates, i.e. the bishops and archbishops and the nobility, and on the other by an elite commons class who had extensive landholdings. There was no relationship between this misnamed latter group and those who are now elected under universal suffrage to the House of Commons. Their only difference from the first group was that they had no hereditary peerage, but they did, of course, exercise much influence on the community because of their wealth and holdings. This elitist clique saw an opportunity in the investiture of the daughter of a deposed monarch and the importation of a foreign, non-English speaking one who was basically uninformed about the English constitution and its protections for the individual, to draft a reformed constitution which would nullify the constitutional power of the monarch and the people, transferring those instead to the Parliament, making the latter supreme. Although there had been a House of Commons since 1263, it was entirely unrepresentative of the vast bulk of the people. People had for centuries been subjected to wealth and property qualifications just to appear on a jury, and don't even ask about an average person getting into Parliament at either level. So the estates set about drafting this duplicitous new constitution, although it could only be classified as an addendum to the existing one, which Parliament has no power to amend, and as we shall see, is both unlawful and illegal. It was touted as the definitive attempt to assert the true place of Parliament as above the monarch, dispensing once and for all with the doctrine of the divine right of kings. It was also touted as a definitive assertion of the rights of the individual, which of course it could never be, as individual rights, as we know, are not the government's or anyone else's to dispense, but exist already in perpetuity by virtue of the person's existence in nature. Any attempt to define such by statute immediately places the individual under the capricious domination of the state, which can change legislation on a whim, especially to suit the interests of the ruling elite. It was also proclaimed as establishing the ascendancy of Protestantism as a religion of state, prohibiting any Catholic from ever again claiming the throne. A summary of the claims and outcomes of the Bill of Rights is shown here. As we see, the outcomes were quite different from what was advertised. The right or duty of the monarch to withhold royal assent in case of treasonous legislation was declared to be illegal. The Parliament thus asserted itself as supreme over the monarch, and the vox populi, or voice of the people, was also stifled. By stipulating that jurors had to have certain financial or asset-based qualifications to be selected, This bill guaranteed that the vast bulk of the people would be forever excluded from participation in judicium parium, equal justice, which was reinstalled by Magna Carta 1215, and was literally the function performed by trial by jury. Under that system, every member of society was empowered to not only be called to sit in judgment on their peers, but also obliged to judge whether the law they were the accused under was itself just. They also had the power to initiate trials by jury for any members of the legislature who had been involved in devising or passing into statute any act which caused harm or loss to people. The jurors were the judges, not only of the facts of the case, but of the justness of the law itself. What we have today, where jurors are instructed by judges as to what they may decide as evidence or just law, are perversions of the true trial by jury system, since a judge being employed by the government, and not therefore fully independent, is inherently unqualified by conflict of interest from deciding on any matter. The Bill of Rights, by its unlawful restrictions, assured that only those belonging to the upper echelons of society could function effectively under the legal system, which of course made it virtually automatic that the interests of that group would be served, and set in stone the establishment of a loathsome class system. Another feature of the bill was that it refused to end the autonomy of the Vatican over the square mile of the City of London. This facilitated the continued influence of Catholic or European interests over British banking and financial concerns, and provided a gateway for the insinuation and strengthening of the Roman or maritime law or law of the sea into Britain's legalese system. This was part of the intention of the Estates Group, which wanted to entirely negate the safeties and guarantees provided by the Magna Carta, enabling the establishment and eventual domination of corporate law systems under which all people would have no rights other than those permitted by the Parliament, and would exist in practice as chattels or property of the ruling class. By waving the red, white and blue flag of Protestant ascendancy, the Estates drew in the masses to this deception. William facilitated this by rejecting signing the declaration, preferring that Parliament present him with a statute for his accession. Thus, there was never any signature for the Declaration of Rights, therefore no contract between the monarch and the people for the upholding of the Constitution. As a statute, therefore, it had no royal assent and is obviously unconstitutional, treasonous, illegitimate and void. It stands as one of the major assaults on the constitutional law as protected by Magna Carta, and effectively established Parliament as an authoritarian dictatorship, the people as a subservient class, and the monarch as a mere figurehead, best suited to cutting ribbons at fetes and other symbolic occasions. On various occasions since the Declaration, the monarch has been urged to regard the denial of royal assent as a theoretical concept, not really to be used in practice. And there is no doubt that Elizabeth II was urged by parliamentarians to ignore the petition of the Committee of Barons in 2001, as indicated by the wording of the response she gave via her private secretary on the 39th day afterwards. However, that response was insufficient to fulfil her constitutional duties, leaving the barons with no choice other than to invoke Article 61. This was done according to correct protocols on March the 23rd of 2001, giving us a sure understanding that Magna Carta 1215 is as valid today as it was when it was first sealed. The treason of the Bill of Rights was and is grievous, but we still have the power and indeed the duty to resist it until the true legem terrae, law of the land, is restored in full. Because of the crucial nature of the coronation oath to the entire constitutional process, this topic will be given more detailed treatment in the next video, as the treatment under the Bill of Rights has led in turn to the treasonous enactment of the Commonwealth of Australia Constitution Act 1900 of the British Parliament, now annulled by the invocation of Article 61. Until next time, thank you for watching.